Tonight's topic is Social Security disability. Making a claim for Social Security benefits is not always as easy as it sounds, especially if you get denied. Knowing about eligibility requirements, medical evidence, appeal procedures, and vocational evaluations can help. Good evening, and welcome to Lawyers on the Line. I am Sean Quinn, and this is Stephanie Balmer, and we both were partners at the law firm of Falsani, Balmer, Peterson Quinn. We'll get to that at the end. And we're ready for your questions. You can call locally at 218-788-2844, or if that's long distance for you, you can call us toll-free 1-877-307-8762. So we'll start with our first question. And I will point out to our viewers that because it's just Stephanie and me, we're kind of going to both each ask questions. So Stephanie, we'll start with you. How does somebody prove that they're disabled?
Well, the definition of whether someone is disabled under the Social Security Act is basically multi-pronged. The Social Security Administration will first look at whether you're working and making substantial gainful activity earnings, which I usually estimate at this point around $12,000 a year.
Okay, about $1,000 a month.
About $1,000 a month, yep.
Okay.
And so if you're not making that money, then they'll start looking at whether you are medically disabled, which consists of showing that you've either already been unable to work for 12 months or you have a condition that's likely to keep you from working 12 months, and you have to prove that with medical evidence.
Okay.
And then the definition of medical disability gets a little more detailed.
Okay. So with this medical evidence, where does it come from?
From doctors
Okay.
and physical therapists and psychologists and all sorts of people. And if you don't have that evidence, either because you haven't been treating or because you have been treating and the notes just don't say much, then it's going to be really hard, if impossible, to win a claim.
Okay. So one of the problems that we deal with all the time is people complaining to us because they're frustrated. This is taking forever.
Yep.
How long does this take?
Well, I usually say if you put in an initial application, it can take anywhere from 1 month to even 6 months to get an initial decision, but I would say usually it's around 2 months, 2 to 3 months.
And that's when the I think it's called DDS, Disability Determination Services, a group of people are making that decision, reviewing your medical evidence and all of the other things that we've talked about already.
Yep. Yep, so they'll look at that. They'll do, and our local field office, I think, has a hand in that too to some extent.
At least in gathering the evidence.
Right, and you know, that again is medical records, you know, contacting clinics and hospitals and whatnot. And so then once there's this decision that you're not disabled, if you get denied, then you have to appeal it. That's called requesting reconsideration. And that decision can take a week or it can take 6 months again.
All right. And how long do you have to request reconsideration?
60 days.
60 days.
Yep.
Don't forget, 60 days.
Yep.
It's always 60 days.
It's always 60 days. And I had a guy call me because he missed the letter in the mail. And so he's coming right up against the deadline. And I usually tell people, if you're right up against the deadline, call. Just call the Social Security office and say, I'm a few days late, you know, I want to appeal, you know, can you guys help me out here?
They might give you a little bit of leeway.
They might, but otherwise they might make you reapply.
Yeah. But the worst thing is calling your lawyer on the 59th day.
Yes, yes.
Nobody likes that.
No, if you get a denial, I would get on the phone right away just because, again, and if you do this appeal, well, you can talk about the stats maybe as far as what are the odds of getting granted.
Yeah, there's the myth is everybody gets denied the first time, and that's not true. No. It's actually a full third of all people get their claims granted at the very beginning, a full third. So those are the people we never see. We never meet those people.
Right.
But 2/3 get denied, and then those people, not everyone appeals.
Right.
But those who do, about 90% get denied again. Why is that?
Well, the fair answer is I don't know. What I suspect is, first of all, the evidence isn't really changing between the initial application and the appeal. there isn't a comprehensive, what I'll call comprehensive analysis of the evidence. I think just the second level, there's supposed to be different people looking at it, but I think they're just opening up the book and saying, no, it looks the same. And
Well,
closing it.
here's the evidence. I say this person's denied. What do you think, Steph?
Yeah, denied.
Yeah,
denied.
it's the same. It's the person next to the person.
Right.
Yeah.
Yep. So so the odds of getting your request for reconsideration granted, I think it's like 8% or something. It's really low.
It's maybe 10 tops.
Yeah.
So then you get denied reconsideration.
You get denied a second time. You should, if you have a good case, you should request a hearing, and that unfortunately is where the real weight lies.
You might be waiting already a year at this point.
Yeah, if you took 6 months to get your initial application denied and then 6 months to get reconsideration issued, and that was a denial, and you request a hearing, you could be even another 2 years, unfortunately.
2 more years.
2 more years on top of that. I looked it up recently. The Minneapolis Social Security Hearing Office is ballparking 22 months from the request for hearing, not the initial application, the request for hearing.
Right.
So, and that's just getting in front of a judge, even then the judge still has a couple months to get you the decision.
Right. And the Minneapolis Hearing Office covers all of northwestern Wisconsin and all of Minnesota from about Hinckley on up, except for the western part of Minnesota.
Right.
Which is handled by Fargo, I believe.
Yes.
So,
Yep.
so if you're in our viewing area, it's probably 2 to 3 years from the initial application to the time you get to meet a judge.
That would, yes, I agree with that.
Okay. So what happens at the hearing now?
Most hearings should involve a live judge. The Social Security Administration is doing.
It's better than a dead judge.
It is better than a dead judge. It's all relative. No, they're offering video conference hearings now in an effort to get rid of some of the backlog, but. And I think you agree with me on this. I prefer a live hearing for various reasons. One being that if someone's going to make such a big decision about their life, I want them 5 feet from you, looking at you, listening to you.
As close as you and I
Yes.
are, that's how close the judge is to the claimant at a hearing.
And so I worry that when you have a video conference connection, that the judge isn't understanding the human element as much as they should. And so that's one reason. Another reason is, when someone's talking to their representative about what bothers them on a day-to-day basis, they frequently overlook things because they've already changed their life to accommodate them. And I had a woman who never told me about her tremors. And I had never noticed her tremors, to be fair. And we're at a hearing, and she had tremors, and the judge noticed the tremors. And that's a huge deal.
Oh, yeah.
So I never forgot that. And so I think that's important, too, as far as evaluating.
The human interaction is always better face-to-face versus through a television screen.
Yeah. So anyway, I got caught up there.
Yeah,
so a video conference hearing, you can't have those. They'll tell you that it's faster. If it is faster, it's only like a month or two. It's not worth it. So you have a hearing of a judge. You typically have a vocational expert. In some cases, you have a medical expert. And everybody's sitting in a hearing room. There's usually a bailiff sitting in the corner. They're private. They're not open to the public. And you spend either 45 minutes or an hour or sometimes even less with the judge taking in evidence about the case from you as the claimant and maybe the medical expert and the vocational expert. So that's the hearing.
So who's representing the Social Security Administration at the hearing?
It's technically a non-adversarial proceeding, but the judge is the Social Security Administration. And so the judge is the one deciding on behalf of the Social Security Administration whether you're disabled or not.
Okay. But there's not another lawyer in the room?
Nope. There's no lawyer trying to cross-examine you. There's nobody trying to trip you up. It's just technically you are the only party to the claim.
All right, and while we've been talking, we already got a call.
Great.
Why do you need an attorney? And if so, if you get one, how does that attorney get paid?
Yeah. So I personally believe you shouldn't need an attorney for Social Security. I think if the system were perfect, it would evaluate the evidence the way that evidence, you're rolling your eyes.
Yeah,
I know, you shouldn't need a lawyer.
perfect.
It's not perfect, and because it's not perfect, and because of the human element, you need a lawyer a lot of the time. Now, not everybody needs a lawyer, and sometimes people call me, and I talk to them, and I say, you know what, you got all this great evidence, you show up, you tell the truth, you'll probably be okay. But it's a big deal, Social Security disability is a lot of money, and so If you're even the least bit inclined, you should at least call a lawyer and see if it's something they can help you with. And I think you do need a lawyer in most of these cases because if you want to make sure all the medical evidence is in, people don't even know what medical evidence they need. You know, a lot of people show up, they say, well, my doctor wrote that I was off work. Why isn't that enough? Well, I will tell you. And then handling the evidence as it comes in during the hearing, you have a medical expert testifying, you have a vocational expert testifying, and you're sitting there going, what's happening? And this is all happening in 45 minutes or an hour, and it's your life that's being decided. So
whether you get monthly benefits or not for a number of years.
Because if you lose, you waited 3 years, you lose all that back pay, you got to start over again. It's not something you want to learn by trial.
Right. Yeah, I think the most important thing that the lawyer does, I've always felt this in my practice, was talking to the client the first time in my office and finding out all their problems and finding out about the problems that they'd never even told Social Security about because they didn't even think it was a big deal.
Right, that's what I'm talking about.
And then you gather all the medical evidence from all the different clinics because, I only told them about the last doctor, not the doctor from 3 years ago or 5 years ago or whatever. And I think that most of the good lawyering is done not at the hearing, before the hearing.
I agree with that. I usually tell people that if I've done my job, then the case should be basically put in by the time the hearing starts. Now again, there's some pitfalls that can happen during the course of a hearing.
Sure.
But nothing really that shocking. We typically know who the experts are and what types of opinions they give, and we know the judges and what their styles are and things like that. So.
All right. So you did all this great work. How do you get paid? That was one of the other part of that question.
That was the other part of that question. So there's a rule that says if you get a Social Security lawyer, the lawyer can be paid a percentage of the back pay. And that's what our retainer agreements say. It says if the representative recovers back pay, then the representative is paid 25% of the back pay up to $6,000. And the back pay, as I describe it on an SSDI claim, when you apply for benefits, you identify a date on which you became disabled. Now, 5 months after that, you don't get paid. It's like a waiting period is the best way I can characterize it. So on that 6 month, though, every month that goes by without your claim being granted, that imaginary money is going into a pot. And once we get your claim granted, the representative takes 25% of that back pay, and it's meant to come directly from Social Security. So when Social Security is doing the math and they say claimant is owed this for back pay, and this is how much claimant gets on a monthly basis, I see that claimant had a representative, and the judge okayed all the paperwork, and so we're going to take out 25% of that back pay and send the rest to the claimant, or in some situations, some of that goes back to DHS or whatever the case may be.
And you said there was a maximum of $6,000.
Capped at $6,000. That has changed. The last time it changed, though, was when?
It has to be more than 10 years ago.
Yeah.
So Congress can change it, but they're not interested in necessarily giving us a raise.
Don't think we're very high on the priority list, no.
Okay. Another caller. A person is on disability. Then they turn 65, and we'll say maybe it's 66 or 67. And what's that person's obligation to tell Social Security that they now should be getting retirement disability? So this question presumes some things that aren't even true, correct?
Yes.
All right. What happens?
Well, at some point you go off SSDI and on to retirement.
Yeah.
As far as an obligation,
I don't think there is an obligation. I think Social Security they stop calling it disability benefits and they start calling it retirement benefits, and the amount stays exactly the same.
Stay the same. I suspect what the caller may be referencing is Social Security will sometimes make people feel, well, you should have told us, or
but not in this situation.
Yeah, that's fair. That's fair.
Yeah, I do know that sometimes people get a letter that'll say, you're no longer disabled, you're now retired. And they get upset about that.
That is a good point because they remain disabled.
Yeah, they still have the same medical problems.
But it's, form letter.
And the disabled is defined by Social Security as not able to work and under the retirement age.
That is a good point. So. Yes. Yep.
Okay. So now here's another one, kind of a similar situation. 62-year-old man. He had a hip replacement. He applied for disability. He was granted disability.
Okay.
62. He's better now. The total hip worked.
Great.
It's moving around much better. That's the whole goal of total hip replacement.
Right.
Does he have to report to Social Security? I'm feeling a lot better now. And we'll expand that question beyond the caller, which is, let's say it's not a 62-year-old man with a hip replacement. Let's say it's a 47-year-old person who had whatever medical surgery that made them feel better.
You know, I believe that if you are no longer medically disabled, and that's the tricky part, so I have a follow-up position, okay? So if you have no pain and you're symptom-free and you're doing everything and you think you could work full-time in a heavy job, I think there may be an obligation there. But what I want to follow it up with is a lot of people think they can do more than they can. And frequently, I find that people who stop working because it was too physically difficult for them, they do start to feel better.
Because they're not pounding their bodies anymore.
Because they're not working.
Yeah.
Because they're disabled.
Yeah.
And so I think that's a boomerang problem.
Yeah.
You know, they have a similar problem with putting, with placing people in advanced care facilities. You know, you go into one of these facilities, you start feeling better because you're getting everything you need every day. Well, it doesn't mean you go out of the facility. It means it's a good fit.
Right.
And the same can be said for Social Security. I mean, so as far as, great, it worked, but you know, you may still not be able to work.
Yeah. And I say if the 62-year-old man with the total hip, a lot of it depends on what he used to do for a living. So
yes.
If he did really heavy work, even though he's feeling better, he probably can't go back to that really heavy work. It'll ruin the total hip. And so I don't think he has an obligation to tell Social Security I'm feeling better under any circumstance. But if you feel well enough to try to go back to work, and then you go back to work, and you actually do go back to work.
That's a good point.
Now you have to tell Social Security, I'm back to work.
And I tell people to be very careful. You know, even if you have a claim pending for Social Security, or if you're getting Social Security and you decide, or you're able to go back to work in some capacity, do not call and cancel your claim.
No.
Do not call and cancel your benefits. First of all, Social Security has a program called a trial
work
period where you can continue receiving Social Security and work. And the idea there is, let's see how this goes.
Right, because if it doesn't work out, we don't have to start the whole process over again.
3 years.
Yeah.
Yes.
Yeah. All right, so now this is a very common situation. Another caller. I got Social Security, and I got a big lump sum back pay, kind of like the back pay we talked about for attorney fees. Now, I'm also getting long-term disability, and they want to take all my money.
Yes.
What's the deal there?
Well, a lot of people don't know that when they sign up for a long-term disability plan, part of the deal and in a term of the policy is that if you get Social Security or a number of other types of benefits, you promise to repay the long-term disability carrier any overlapping benefits. So if there was a month where you got both Social Security and long-term disability. Now, what can be confusing is if you get one type of benefit, not the other. For example, if you're getting long-term disability, you haven't gotten Social Security yet, and then you get this back pay, long-term disability wants their money back.
Right.
And typically, you have to give it to them.
Yeah, and one of the things, and people always forget this, when you apply for the long-term, all the plans say the same thing. There's a form that they have you sign where it says, I know I'm not getting Social Security, but if I get it, I realize I have to pay you back. Mm-hmm. And you could elect to receive a smaller amount, where they reduce it by the Social Security that you're not even receiving yet. With
the expectation,
yeah,
you know, because and this is a related question, but well, how can long-term disability consider me disabled, but Social Security isn't? Well, you know, a long-term disability decision isn't binding on Social Security, and Social Security decision isn't binding on long-term disability. Do they look at each other? Yes, and that's why it's likely that if you're getting one, you will get the other, but it's not a sure thing.
No, and they do technically have different definitions of disability. Yep. So in that situation, the long-term carrier has a contract. The contract says they get that back pay back. Mm-hmm. I mean, that's the answer.
Yeah, it's tough, but it's unfortunately what you signed up for when you first got the policy.
Right.
Yeah.
All right, so another caller. A woman was awarded disability about 4 or 5 years ago. Does Social Security ever get back in touch with her and say, we're checking to see if you're still disabled?
They might. A lot of it depends on her age, frankly, and then also on her medical condition. So if you're a younger individual, under the age of 50,
they're going to get back in touch.
They're going to get back in touch with you. You know, and sometimes I've had cases where people in their 20s or even 30s have been awarded, and that's been part of the judge's decision. You know, the review issue is frequently a field office issue, or your local office. But some of these judges, they gotta grant the claim. They don't like it, but they gotta. And so part of it is, but I want this reviewed in 3 years.
Right.
So.
Right. And I actually think there is it's either in the statute or the rules that actually mandates the Social Security
under a certain age.
Review every 5 to 7 years. And Social Security typically, because of lack of manpower, hasn't been doing it. But they're under a lot of directives to do that.
Yeah.
So,
well, and they'll analyze it according to likelihood of that actually going somewhere, and that's why the age comes into play. The odds of a 55-year-old improving significantly within 3 years are much lower than a 25-year-old. So.
okay. So, very common complaint here. How come they denied my claim? There's a guy living down the street. I see him out in his lawn every day, mowing his lawn, doing the thing, and I know he's on disability and there's nothing even wrong with him.
I would say approximately 40% of my Social Security clients say that at some point during one of our meetings. And I think part of it is sheer frustration, with the system. And what I tell those people, and I didn't used to comment on it, but now I do. I tell these people, first, you don't know what is in that person's medical chart. You do not know what demons that person is dealing with. There are a lot of hidden disabilities.
Right. Can't see mental health problems at all.
You can't see mental health problems. So just because he's out there building a roof on his house doesn't mean he's not dealing with a really severe mental health issue that they're struggling to medicate. I mean, You just don't know. People think they know. You don't know. The other issue is, why do you think they denied your claim but granted his? That seems silly, doesn't it? Well, who's making that decision? If he really isn't disabled, why would they grant that one and not yours? It doesn't make any sense.
No.
So.
No. Now, how come a judge ultimately, or that DDS office earlier, these aren't doctors? Why are they the ones who get to make this final call?
I do not know what their training is. I assume they have some training, the staff people at the Social Security Administration and DDS, which is a state agency that works with the feds. I believe they have some medical training and they know what they're looking for in the medical records. They're looking for in most cases, objective findings, unfortunately, which don't always exist for a lot of these conditions. They're looking for x-rays, MRIs, neuropsychological testing, really good proof of disability. And so if you are very disabled, but you don't have a lot of proof, they might pass you by and might have to wait for a judge.
Yeah. Well, there was a Supreme Court justice, and I can't remember who it was, many, many years ago, who said, we're not last because we're infallible. We're infallible because we're last.
Huh.
Somebody has to make the final decision.
Yeah, that's true.
And, it's a judge. A judge gets to decide. But the judge relies upon the doctors, your doctors that examined you, wrote reports, the doctors that DDS hired to look at the records. Mm-hmm. But somebody has to put it all together. It's just like a jury makes a decision on whether someone committed a crime.
Yeah, and that's why sometimes your claim gets granted, a couple weeks before the hearing. You waited 3 years, and it wasn't until a judge or the judge's right-hand person picked up the file and looked at it and started putting it together. Oh, you didn't have to wait 3 years, but here we are.
Okay. Another common question. I have fill in the blank, any medical condition. We've heard them all. I have this condition. Do I win?
That depends.
That's the answer.
Yes, and a lot of people have ideas about conditions and severities and things like that, but a lot of inflammatory arthritis conditions are the best example. Some people are really high functioning and very well treated and very well medicated, and they respond to treatment and they're doing everything right and they're lucky.
Even though they have terrible rheumatoid arthritis.
Yes, other people are completely debilitated by it. We're humans, not robots. And so that's why we go back to the medical records. What are your doctors saying about you in your records?
Yeah.
So it depends.
Now, there is a certain list of some medical conditions that are at least supposed to be, in theory, you win.
Yes.
If you have it, you win,
yes.
Period.
Yeah, there's two versions of those. One is the compassionate allowance condition, where if you have a condition on this list, which unfortunately keeps getting longer as they come up with new medical conditions, that's like stage 4 cancer and organ failure, and they're really, really horrible conditions. You're meant to get it right away. We don't see a lot of those.
No.
Because those typically get granted. But what we're also talking about are the listed impairments, and those are, I think, 13 chapters of different medical conditions, where if you have one of these conditions and you have the symptoms of the requisite level of severity defined in the listings, then you're meant to qualify.
And even then,
maybe.
Yeah, maybe.
Yeah.
So, all right. So that's all the time we have tonight. Thanks for a great discussion with Stephanie. I hope everyone tunes in again next week when Lawyers on the Line talks about premises liability claims. Now tonight, I need to say a special goodbye. I mentioned earlier Stephanie and I used to be partners. This is my last show ever. A few weeks ago, I was appointed by Governor Dayton to be a judge on the Workers' Compensation Court of Appeals, which is a special court for workers' comp appeals. I start that job Monday. What is that, 4 days from now?
Yep.
Something like that.
5. 4.
So I have to leave my law firm. My last official day at my law firm was last Friday. And I have to leave Duluth and I have to go to St. Paul. It's been my pleasure, my sincere pleasure, to represent so many of you over my 26 years with the firm. It's been my pleasure to appear on this show so many times, sometimes as a panelist, sometimes as a moderator. I can't thank the staff here at WDSE enough for all their kindness and courtesies over the years. I also want to thank all of the people who've been answering the phones over the years. I'm going to miss this set, the people here at the TV station, my law firm, all the lawyers, Stephanie, all the staff there, all my wonderful clients. I have this terrific view of Lake Superior out of my office. I lose that. I'm going to miss the whole community of Duluth and Superior. I moved here 26 years ago to take the job that I have at my firm. They opened their arms up to me. This entire community opened up their arms to me. My kids were born here. They were raised here. I've lived in Duluth longer than I've lived in any single place in my entire life. I'm very excited about my new adventure coming up, but I will always consider Duluth to be my home, and I will do my best to visit as often as I can. Good night and goodbye. Yay.